2019 amendments to the 1997 Rules of Civil Procedure, AM No. 19-10-20 SC. Rule 15 Motions. Section 1. Motion defined. A motion is an application for relief other than by a pleading. Section 2. Motions must be in writing. All motions shall be in writing except those made in open court or in the course of a hearing or trial. A motion made in open court or in the course of a hearing or trial should immediately be resolved in open court after the adverse party is given the opportunity to argue his or her opposition thereto. When a motion is based on facts not appearing on record, the court may hear the matter on affidavits or depositions presented by the respective parties, but the court may direct that the matter be heard wholly or partly on oral testimony or depositions. Section 3. Contents. A motion shall state the relief sought to be obtained and the grounds upon which it is based, and if required by these rules or necessary to prove facts alleged therein, shall be accompanied by supporting affidavits and other papers. Section 4. Hearing of motion. Deleted. Section 4. Non-litigious motions. Motions which the court may act upon without prejudicing the rights of adverse parties are non-litigious motions. These motions include motion for the issuance of an alias summons, motion for extension to file answer, motion for postponement, motion for the issuance of a writ of execution, motion for the issuance of an alias writ of execution, motion for the issuance of a writ of possession, motion for the issuance of an order directing the sheriff to execute the final certificate of sale, and other similar motions. These motions shall not be set for hearing and shall be resolved by the court within 5 calendar days from receipt thereof. Section 5. Litigious motions. A. Litigious motions include motion for bill of particulars, motion to dismiss, motion for new trial, motion for reconsideration, motion for execution pending appeal, motion to amend after a responsive pleading has been filed, motion to cancel statutory lien, motion for an order to break in or for a writ of demolition, motion for intervention, motion for judgment on the pleadings, motion for summary judgment, demur to evidence, motion to declare defendant in default, and other similar motions. All motions shall be served by personal service, accredited private courier or registered mail, or electronic means so as to ensure their receipt by the other party. The opposing party shall file his or her opposition to a litigious motion within 5 calendar days from receipt thereof. No other submissions shall be considered by the court in the resolution of the motion. The motion shall be resolved by the court within 15 calendar days from its receipt of the opposition thereto, or upon expiration of the period to file such opposition. Section 6. Notice of hearing on litigious motions, discretionary. The court may, in the exercise of its discretion, and if deemed necessary for its resolution, call a hearing on the motion. The notice of hearing shall be addressed to all parties concerned, and shall specify the time and date of the hearing. Section 7. Proof of service necessary. No written motion shall be acted upon by the court without proof of service thereof, pursuant to Section 5(b) hereof. Section 8. Motion day. Except for motions requiring immediate action, where the court decides to conduct hearing on a litigious motion, the same shall be set on a Friday. Section 9. Omnibus motion. Subject to the provisions of Section 1 of Rule 9, a motion attacking a pleading, order, judgment, or proceeding shall include all objections then available, and all objections not so included shall be deemed waived. Section 10. Motion for leave. A motion for leave to file a pleading or motion shall be accompanied by the pleading or motion sought to be admitted. Section 11. Form. The rules applicable to pleadings shall apply to written motions so far as concerns caption, designation, signature, and other matters of form. Section 12. Prohibited motions. The following motions shall not be allowed. Motion to dismiss except on the following grounds: that the court has no jurisdiction over the subject matter of the claim, that there is another action pending between the same parties for the same cause, and that the cause of action is barred by a prior judgment or by the statute of limitations. Motion to hear affirmative defenses. Motion for reconsideration of the court's action on the affirmative defenses. Motion to suspend proceedings without a temporary restraining order or injunction issued by a higher court. Motion for extension of time to file pleadings, affidavits, or any other papers, except a motion for extension to file an answer as provided by Section 11, Rule 11, and motion for postponement intended for delay, except if it is based on acts of God, force majeure, or physical inability of the witness to appear and testify. If the motion is granted based on such exceptions, the moving party shall be warned that the presentation of its evidence must still be terminated on the dates previously agreed upon. A motion for postponement, whether written or oral, shall, at all times, be accompanied by the original official receipt from the office of the clerk of court evidencing payment of the postponement fee under Section 21(b), Rule 141. to be submitted either at the time of the filing of said motion or not later than the next hearing date. The clerk of court shall not accept the motion unless accompanied by the original receipt. Section 13. Dismissal with prejudice. Subject to the right of appeal, an order granting a motion to dismiss or an affirmative defense that the cause of action is barred by a prior judgment or by the statute of limitations, that the claim or demand set forth in the plaintiff's pleading has been paid, waived, abandoned or otherwise extinguished, or that the claim on which the action is founded is unenforceable under the provisions of the statute of frauds, shall bar the refiling of the same action or claim. Rule 16. Motion to dismiss. Provisions either deleted or transposed. Rule 17. Dismissal of actions. Section 1. Dismissal upon notice by plaintiff. A complaint may be dismissed by the plaintiff by filing a notice of dismissal at any time before service of the answer or of a motion for summary judgment. Upon such notice being filed, the court shall issue an order confirming the dismissal. Unless otherwise stated in the notice, the dismissal is without prejudice, except that a notice operates as an adjudication upon the merits when filed by a plaintiff who has once dismissed in a competent court an action based on or including the same claim. Section 2. Dismissal upon motion of plaintiff. Except as provided in the preceding action, a complaint shall not be dismissed at the plaintiff's instance save upon approval of the court and upon such terms and conditions as the court deems proper. If a counterclaim has been pleaded by a defendant prior to the service upon him or her of the plaintiff's motion for dismissal, the dismissal shall be limited to the complaint. The dismissal shall be without prejudice to the right of the defendant to prosecute his or her counterclaim in a separate action unless within 15 calendar days from notice of the motion he or she manifests his or her preference to have his or her counterclaim resolved in the same action. Unless otherwise specified in the order, a dismissal under this paragraph shall be without prejudice. A class suit shall not be dismissed or compromised without the approval of the court. Section 3. Dismissal due to fault of plaintiff. If, for no justifiable cause, the plaintiff fails to appear on the date of the presentation of his or her evidence in chief on the complaint, or to prosecute his or her action for an unreasonable length of time, or to comply with these rules or any order of the court, the complaint may be dismissed upon motion of the defendant or upon the court's own motion, without prejudice to the right of the defendant to prosecute his or her counterclaim in the same or in a separate action. This dismissal shall have the effect of an adjudication upon the merits, unless otherwise declared by the court. Section 4. Dismissal of counterclaim, cross-claim, or third-party complaint. The provisions of this rule shall apply to the dismissal of any counterclaim, cross-claim, or third-party complaint. A voluntary dismissal by the claimant by notice as in Section 1 of this rule shall be made before a responsive pleading or a motion for summary judgment is served or, if there is none, before the introduction of evidence at the trial or hearing. Rule 18. PRE trial. Section 1. When conducted. After the last responsive pleading has been served and filed, the branch clerk of court shall issue, within 5 calendar days from filing, a notice of pretrial which shall be set not later than 60 calendar days from the filing of the last responsive pleading. Section 2. Nature and purpose. The pretrial is mandatory and should be terminated promptly. The court shall consider the possibility of an amicable settlement or of a submission to alternative modes of dispute resolution, the simplification of the issues, the possibility of obtaining stipulations or admissions of facts and of documents to avoid unnecessary proof, the limitation of the number and identification of witnesses, and the setting of trial dates, the advisability of a preliminary reference of issues to a commissioner, the propriety of rendering judgment on the pleadings or summary judgment, or of dismissing the action should a valid ground therefore be found to exist, the requirement for the parties to mark their respective evidence if not yet marked in the judicial affidavits of their witnesses, examine and make comparisons of the adverse party's evidence vis-a-vis the copies to be marked, manifest for the record stipulations regarding the faithfulness of the reproductions and the genuineness and due execution of the adverse party's evidence, reserve evidence not available at the pretrial, but only in the following manner. For testimonial evidence, by giving the name or position and the nature of the testimony of the proposed witness. For documentary evidence and other object evidence, by giving a particular description of the evidence. No reservation shall be allowed if not made in the manner described above. Such other matters as may aid in the prompt disposition of the action. The failure without just cause of a party and counsel to appear during pretrial, despite notice, shall result in a waiver of any objections to the faithfulness of the reproductions marked, or their genuineness and due execution. The failure without just cause of a party and or counsel to bring the evidence required shall be deemed a waiver of the presentation of such evidence. The branch clerk of court shall prepare the minutes of the pretrial, which shall have the following format, see prescribed form. Section 3. Notice of pretrial. The notice of pretrial shall include the dates respectively set for pretrial, court-annexed mediation, and Judicial dispute resolution, if necessary. The notice of pretrial shall be served on counsel or on the party, if he or she has no counsel. The counsel served with such notice is charged with the duty of notifying the party represented by him or her. Non-appearance at any of the foregoing settings shall be deemed as non-appearance at the pre-trial and shall merit the same sanctions under Section 5 hereof. Section 4. Appearance of parties. It shall be the duty of the parties and their counsel to appear at the pretrial, court annex mediation, and judicial dispute resolution, if necessary. The non-appearance of a party and counsel may be excused only for acts of God, force majeure, or duly substantiated physical inability. A representative may appear on behalf of a party, but must be fully authorized in writing to enter into an amicable settlement, to submit to alternative modes of dispute resolution, and to enter into stipulations or admissions of facts and documents. Section 5. Effective failure to appear. When duly notified, the failure of the plaintiff and counsel to appear without valid cause when so required, pursuant to the next preceding section, shall cause the dismissal of the action. The dismissal shall be with prejudice unless otherwise ordered by the court. A similar failure on the part of the defendant and counsel shall be cause to allow the plaintiff to present his or her evidence ex parte within 10 calendar days from termination of the pretrial, and the court to render judgment on the basis of the evidence offered. Section 6. Pretrial brief. The parties shall file with the court and serve on the adverse party in such manner as shall ensure their receipt thereof at least 3 calendar days before the date of the pretrial, their respective pretrial briefs which shall contain, among others, a concise statement of the case and the reliefs prayed for, a summary of admitted facts and proposed stipulation of facts, the main factual and legal issues to be tried or resolved, the propriety of referral of factual issues to commissioners, the documents or other object evidence to be marked, stating the purpose thereof, the names of the witnesses and the summary of their respective testimonies, and a brief statement of points of law and citation of authorities. Failure to file the pretrial brief shall have the same effect as failure to appear at the pretrial. Section 7. Pretrial order. Upon termination of the pretrial, the court shall issue an order within 10 calendar days which shall recite in detail the matters taken up. The order shall include an enumeration of the admitted facts, the minutes of the pretrial conference, the legal and factual issues /s to be tried, the applicable law, rules, and jurisprudence, the evidence marked, the specific trial dates for continuous trial, which shall be within the period provided by the rules, the case flowchart to be determined by the court, which shall contain the different stages of the proceedings up to the promulgation of the decision, and the use of timeframes for each stage in setting the trial dates, a statement that the one-day examination of witness rule and most important witness rule under AM number 03-1-09, SC, guidelines for pretrial, shall be strictly followed, and a statement that the court shall render judgment on the pleadings or summary judgment, as the case may be. The direct testimony of witnesses for the plaintiff shall be in the form of judicial affidavits. After the identification of such affidavits, cross-examination shall proceed immediately. Postponement of presentation of the parties' witnesses at a scheduled date is prohibited, except if it is based on acts of God, force majeure, or duly substantiated physical inability of the witness to appear and testify. The party who caused the postponement is warned that the presentation of its evidence must still be terminated within the remaining dates previously agreed upon. Should the opposing party fail to appear without valid cause stated in the next preceding paragraph, the presentation of the scheduled witness will proceed with the absent party being deemed to have waived the right to interpose objection and conduct cross-examination. The contents of the pretrial order shall control the subsequent proceedings, unless modified before trial to prevent manifest injustice. Section 8. Court Annex Mediation. After pretrial and after issues are joined, the court shall refer the parties for mandatory court annex mediation. The period for court annex mediation shall not exceed 30 calendar days without further extension. Section 9. Judicial Dispute Resolution. Only if the judge of the court to which the case was originally raffled is convinced that settlement is still possible, the case may be referred to another court for judicial dispute resolution. The judicial dispute resolution shall be conducted within a non-extendable period of 15 calendar days from notice of failure of the court annex mediation. If judicial dispute resolution fails, trial before the original court shall proceed on the dates agreed upon. All proceedings during the court annex mediation and the judicial dispute resolution shall be confidential. Section 10. Judgment after pretrial. Should there be no more controverted facts, or no more genuine issue as to any material fact, or an absence of any issue, or should the answer fail to tender an issue, the court shall, without prejudice to a party moving for judgment on the pleadings under Rule 34 or summary judgment under Rule 35, motu proprio include in the pretrial order that the case be submitted for summary judgment or judgment on the pleadings, without need of position papers or memoranda. In such cases, judgment shall be rendered within 90 calendar days from termination of the pretrial. The order of the court to submit the case for judgment pursuant to this rule shall not be the subject to appeal or certiorari. Rule 19 Intervention. Section 1. Who may intervene? A person who has a legal interest in the matter in litigation, or in the success of either of the parties, or an interest against both, or is so situated as to be adversely affected by a distribution or other disposition of property in the custody of the court or of an officer thereof may, with leave of court, be allowed to intervene in the action. The court shall consider whether or not the intervention will unduly delay or prejudice the adjudication of the rights of the original parties, and whether or not the intervener's rights may be fully protected in a separate proceeding. Section 2. Time to intervene. The motion to intervene may be filed at any time before rendition of judgment by the trial court. A copy of the pleading and intervention shall be attached to the motion and served on the original parties. Section 3. Pleadings and intervention. The intervener shall file a complaint in intervention if he or she asserts a claim against either or all of the original parties, or an answer in intervention if he or she unites with the defending party in resisting a claim against the latter. Section 4. Answer to complaint in intervention. The answer to the complaint and intervention shall be filed within 15 calendar days from notice of the order admitting the same, unless a different period is fixed by the court. Rule 20 Calendar of Cases. Section 1. Calendar of Cases. The clerk of court, under the direct supervision of the judge, shall keep a calendar of cases for pretrial, for trial, those whose trials were adjourned or postponed, and those with motions to set for hearing. Preference shall be given to habeas corpus cases, election cases, special civil actions, and those so required by law. Section 2. Assignment of cases. The assignment of cases to the different branches of a court shall be done exclusively by raffle. The assignment shall be done in open session of which adequate notice shall be given so as to afford interested parties the opportunity to be present. Rule 21 Subpoena. Section 1. Subpoena and subpoena duces tecum. Subpoena is a process directed to a person requiring him or her to attend and to testify at the hearing or the trial of an action, or at any investigation conducted by competent authority, or for the taking of his or her deposition. It may also require him to bring with him or her any books, documents, or other things under his or her control, in which case it is called a subpoena duces tecum. Section 2. By whom issued? The subpoena may be issued by the court before whom the witness is required to attend, the court of the place where the deposition is to be taken, the officer or body authorized by law to do so in connection with investigations conducted by said officer or body, or any justice of the Supreme Court or the Court of Appeals in any case or investigation pending within the Philippines. When application for a subpoena to a prisoner is made, the judge or officer shall examine and study carefully such application to determine whether the same is made for a valid purpose. No prisoner sentenced to death, reclusion perpetua or life imprisonment, and who is confined in any penal institution shall be brought outside the penal institution for appearance or attendance in any court unless authorized by the Supreme Court. Section 3. Form and contents. A subpoena shall state the name of the court and the title of the action or investigation, shall be directed to the person whose attendance is required, and in the case of a subpoena duces tecum, it shall also contain a reasonable description of the books, documents or things demanded which must appear to the court prima facie relevant. Section 4. Quashing a subpoena. The court may quash a subpoena duces tecum upon motion promptly made and, in any event, at or before the time specified therein if it is unreasonable and oppressive, or the relevancy of the books, documents, or things does not appear, or if the person in whose behalf the subpoena is issued fails to advance the reasonable cost of the production thereof. The court may quash a subpoena ad testificandum on the ground that the witness is not bound thereby. In either case, the subpoena may be quashed on the ground that the witness fees and kilometerage allowed by these rules were not tendered when the subpoena was served. Section 5. Subpoena for depositions. Proof of service of a notice to take a deposition, as provided in sections 15 and 25 of Rule 23, shall constitute sufficient authorization for the issuance of subpoenas for the persons named in said notice by the clerk of the court of the place in which the deposition is to be taken. The clerk shall not, however, issue a subpoena duces tecum to any such person without an order of the court. Section 6. Service. Service of a subpoena shall be made in the same manner as personal or substituted service of summons. The original shall be exhibited and a copy thereof delivered to the person on whom it is served. The service must be made so as to allow the witness a reasonable time for preparation and travel to the place of attendance. Costs for court attendance and the production of documents and other materials subject of the subpoena shall be tendered or charged accordingly. Section 7. Personal appearance in court. A person present in court before a judicial officer may be required to testify as if he or she were in attendance upon a subpoena issued by such court or officer. Section 8. Compelling attendance. In case of failure of a witness to attend, the court or judge issuing the subpoena, upon proof of the service thereof and of the failure of the witness, may issue a warrant to the sheriff of the province, or his or her deputy, to arrest the witness and bring him or her before the court or officer where his or her attendance is required, and the cost of such warrant and seizure of such witness shall be paid by the witness, if the court issuing it shall determine that his or her failure to answer the subpoena was willful and without just excuse. Section 9. Contempt. Failure by any person without adequate cause to obey a subpoena served upon him or her shall be deemed a contempt of the court from which the subpoena is issued. If the subpoena was not issued by a court, the disobedience thereto shall be punished in accordance with the applicable law or rule. Section 10. Exceptions. The provisions of Sections 8 and 9 of this rule shall not apply to a witness who resides more than 100 kilometers from his or her residence to the place where he or she is to testify by the ordinary course of travel, or to a detention prisoner if no permission of the court in which his or her case is pending was obtained. Rule 22. Computation of time. Section 1. How to compute time. In computing any period of time prescribed or allowed by these rules, or by order of the court, or by any applicable statute, the day of the act or event from which the designated period of time begins to run is to be excluded and the date of performance included. If the last day of the period, as thus computed, falls on a Saturday, a Sunday, or a legal holiday in the place where the court sits, the time shall not run until the next working day. Section 2. Effective interruption. Should an act be done which effectively interrupts the running of the period, the allowable period after such interruption shall start to run on the day after notice of the cessation of the cause thereof. The day of the act that caused the interruption shall be excluded in the computation of the period. Rule 23. Depositions pending actions. Section 1. Depositions pending action when may be taken. Upon ex parte motion of a party, the testimony of any person, whether a party or not, may be taken by deposition upon oral examination or written interrogatories. The attendance of witnesses may be compelled by the use of a subpoena as provided in Rule 21. Depositions shall be taken only in accordance with these rules. The deposition of a person confined in prison may be taken only by leave of court on such terms as the court prescribes. Section 2. Scope of examination. Unless otherwise ordered by the court as provided by Section 16 or 18 of this rule, the deponent may be examined regarding any matter, not privileged, which is relevant to the subject of the pending action, whether relating to the claim or defense of any other party, including the existence, description, nature, custody, condition, and location of any books, documents, or other tangible things, and the identity and location of persons having knowledge of relevant facts. Section 3. Examination and cross-examination. Examination and cross-examination of deponents may proceed as permitted at the trial under Sections 3 to 18 of Rule 132. Section 4. Use of depositions. At the trial or upon the hearing of a motion or an interlocutory proceeding, any part or all of a deposition, so far as admissible under the rules of evidence, may be used against any party who was present or represented at the taking of the deposition or who had due notice thereof, in accordance with any one of the following provisions. Any deposition may be used by any party for the purpose of contradicting or impeaching the testimony of the deponent as a witness. The deposition of a party or of anyone who at the time of taking the deposition was an officer, director, or managing agent of a public or private corporation, partnership, or association which is a party may be used by an adverse party for any purpose. The deposition of a witness, whether or not a party, may be used by any party for any purpose if the court finds 1. That the witness is dead, or 2. That the witness resides at a distance more than 100 kilometers from the place of trial or hearing, or is out of the Philippines, unless it appears that his or her absence was procured by the party offering the deposition, or 3. That the witness is unable to attend or testify because of age, sickness, infirmity, or imprisonment, or 4. That the party offering the deposition has been unable to procure the attendance of the witness by subpoena, or 5. Upon application and notice, that such exceptional circumstances exist as to make it desirable, in the interest of justice and with due regard to the importance of presenting the testimony of witnesses orally in open court, to allow the deposition to be used, and if only part of a deposition is offered in evidence by a party, the adverse party may require him or her to introduce all of it which is relevant to the part introduced, and any party may introduce any other parts. Section 5. Effective substitution of parties. Substitution of parties does not affect the right to use depositions previously taken, and when an action has been dismissed and another action involving the same subject is afterward brought between the same parties or their representatives or successors in interest, all depositions lawfully taken and duly filed in the former action may be used in the latter as if originally taken therefore. Section 6. Objections to admissibility. Subject to the provisions of Section 29 of this rule, objections may be made at the trial or hearing to receiving in evidence any deposition or part thereof for any reason which would require the exclusion of the evidence if the witness were then present and testifying. Section 7. Effect of taking depositions. A party shall not be deemed to make a person his or her own witness for any purpose by taking his or her deposition. Section 8. Effect of using depositions. The introduction in evidence of the deposition, or any part thereof for any purpose other than that of contradicting or impeaching the deponent makes the deponent the witness of the party introducing the deposition. But this shall not apply to the use by an adverse party of a deposition as described in paragraph B of Section 4 of this rule. Section 9. Rebutting deposition. At the trial or hearing, any party may rebut any relevant evidence contained in a deposition whether introduced by him or her or by any other party. Section 10. Persons before whom depositions may be taken within the Philippines. Within the Philippines, depositions may be taken before any judge, notary public, or the person referred to in Section 14 hereof. Section 11. Persons before whom depositions may be taken in foreign countries. In a foreign state or country, depositions may be taken, a. on notice before a secretary of embassy or legation, consul general, consul, vice consul, or consular agent of the Republic of the Philippines, b. before such person or officer as may be appointed by commission or under letters rogatory, or c. the person referred to in Section 14 hereof. Section 12. Commission or letters rogatory. A commission or letters rogatory shall be issued only when necessary or convenient, on application and notice, and on such terms and with such direction as are just and appropriate. Officers may be designated in notices or commissions either by name or descriptive title, and letters rogatory may be addressed to the appropriate judicial authority in the foreign country. Section 13. Disqualification by interest. No deposition shall be taken before a person who is a relative within the 6th degree of consanguinity or affinity, or employee or counsel of any of the parties, or who is a relative within the same degree, or employee of such counsel, or who is financially interested in the action. Section 14. Stipulations regarding taking of depositions. If the parties so stipulate in writing, depositions may be taken before any person authorized to administer oaths, at any time or place, in accordance with these rules, and when so taken may be used like other depositions. Section 15. Deposition upon oral examination. Notice, time and place. A party desiring to take the deposition of any person upon oral examination shall give reasonable notice in writing to every other party to the action. The notice shall state the time and place for taking the deposition and the name and address of each person to be examined, if known, and if the name is not known. A general description sufficient to identify him or her or the particular class or group to which he or she belongs. On motion of any party upon whom the notice is served, the court may for cause shown enlarge or shorten the time. 15a. Section 16. Orders for the protection of parties and deponents. After notice is served for taking a deposition by oral examination, upon motions seasonably made by any party or by the person to be examined and for good cause shown, the court in which the action is pending may make the following orders. That the deposition shall not be taken. That the deposition may be taken only at some designated place other than that stated in the notice. That the deposition may be taken only on written interrogatories. That certain matters shall not be inquired into. That the scope of the examination shall be held with no one present except the parties to the action and their officers or counsel. That after being sealed the deposition shall be opened only by order of the court. That secret processes, developments, or research need not be disclosed, or that the parties shall simultaneously file specified documents or information enclosed in sealed envelopes to be opened as directed by the court. The court may make any other order which justice requires to protect the party or witness from annoyance, embarrassment, or oppression. Section 17. Record of examination, oath, objections. The officer before whom the deposition is to be taken shall put the witness on oath and shall personally, or by someone acting under his or her direction and in his or her presence, record the testimony of the witness. The testimony shall be taken stenographically unless the parties agree otherwise. All objections made at the time of the examination to the qualifications of the officer taking the deposition, or to the manner of taking it, or to the evidence presented, or to the conduct of any party, and any other objection to the proceedings, shall be noted by the officer upon the deposition. Evidence objected to shall be taken subject to the objections. In lieu of participating in the oral examination, parties served with notice of taking a deposition may transmit written interrogatories to the officers, who shall propound them to the witness and record the answers verbatim. Section 18. Motion to terminate or limit examination. At any time during the taking of the deposition, on motion or petition of any party or of the deponent, and upon a showing that the examination is being conducted in bad faith or in such manner as unreasonably to annoy, embarrass, or oppress the deponent or party, the court in which the action is pending or the regional trial court of the place where the deposition is being taken may order the officer conducting the examination to cease forthwith from taking the deposition, or may limit the Scope and manner of the taking of the deposition, as provided in Section 16 of this rule. If the order made terminates the examination, it shall be resumed thereafter only upon the order of the court in which the action is pending. Upon demand of the objecting party or deponent, the taking of the deposition shall be suspended for the time necessary to make a notice for an order. In granting or refusing such order, the court may impose upon either party or upon the witness the requirement to pay such costs or expenses as the court may deem reasonable. Section 19. Submission to witness, changes, signing. When the testimony is fully transcribed, the deposition shall be submitted to the witness for examination and shall be read to or by him or her, unless such examination and reading are waived by the witness and by the parties. Any changes in form or substance which the witness desires to make shall be entered upon the deposition by the officer with a statement of the reasons given by the witness for making them. The deposition shall then be signed by the witness, unless the parties by stipulation waive the signing or the witness is ill or cannot be found or refuses to sign. If the deposition is not signed by the witness, the officer shall sign it and state on the record the fact of the waiver or of the illness or absence of the witness, or the fact of the refusal to sign together with the reason given therefor, if any. And the deposition may then be used as fully as though signed, unless on a motion to suppress under Section 29 F of this rule. The court holds that the reasons given for the refusal to sign require rejection of the deposition in whole or in part. Section 20. Certification and filing by officer. The officer shall certify on the deposition that the witness was duly sworn to by him or her, and that the deposition is a true record of the testimony given by the witness. He or she shall then securely seal the deposition in an envelope endorsed with the title of the action and marked Deposition of, here insert the name of witness, and shall promptly file it with the court in which the action is pending or send it by registered mail to the clerk thereof for filing. Section 21. Notice of filing. The officer taking the deposition shall give prompt notice of its filing to all the parties. Section 22. Furnishing copies. Upon payment of reasonable charges therefor, the officer shall furnish a copy of the deposition to any party or to the deponent. Section 23. Failure to attend of party giving notice. If the party giving the notice of the taking of a deposition fails to attend and proceed therewith and another attends in person or by counsel pursuant to the notice, the court may order the party giving the notice to pay such other party the amount of the reasonable expenses incurred by him or her and his or her counsel in so attending, including reasonable attorney's fees. Section 24. Failure of party giving notice to serve subpoena. If the party giving the notice of the taking of a deposition of a witness fails to serve a subpoena upon him or her and the witness, because of such failure does not attend, and if another party attends in person or by counsel because he or she expects the deposition of that witness to be taken, the court may order the party giving the notice to pay to such other party the amount of the reasonable expenses incurred by him or her and his or her counsel in so attending, including reasonable attorney's fees. Section 25. Deposition upon written interrogatories, service of notice and of interrogatories. A party desiring to take the deposition of any person upon written interrogatories shall serve them upon every other party with a notice stating the name and address of the person who is to answer them and the name or descriptive title and address of the officer before whom the deposition is to be taken. Within 10 calendar days thereafter, a party so served may serve cross-interrogatories upon the party proposing to take the deposition. Within 5 calendar days thereafter, the latter may serve redirect interrogatories upon a party who has served cross-interrogatories. Within 3 calendar days after being served with redirect interrogatories, a party may serve recross interrogatories upon the party proposing to take the deposition. Section 26. Officers to take responses and prepare record. A copy of the notice and copies of all interrogatories served shall be delivered by the party taking the deposition to the officer designated in the notice, who shall proceed promptly, in the manner provided by Sections 17, 19 and 20 of this rule, to take the testimony of the witness in response to the interrogatories and to prepare, certify, and file or mail the deposition, attaching thereto the copy of the notice and the interrogatories received by him or her. Section 27. Notice of filing and furnishing copies. When a deposition upon interrogatories is filed, the officer taking it shall promptly give notice thereof to all the parties, and may furnish copies to them or to the deponent upon payment of reasonable charges therefor. Section 28. Orders for the protection of parties and deponents. After the service of the interrogatories and prior to the taking of the testimony of the deponent, the court in which the action is pending, on motion promptly made by a party or a deponent, and for good cause shown, may make any order specified in Sections 15, 16 and 18 of this rule which is appropriate and just, or an order that the deposition shall not be taken before the officer designated in the notice, or that it shall not be taken except upon oral examination. Section 29. Effective errors and irregularities in depositions. As to notice, all errors and irregularities in the notice for taking a deposition are waived unless written objection is promptly served upon the party giving the notice. As to disqualification of officer, Objection to taking a deposition because of disqualification of the officer before whom it is to be taken is waived unless made before the taking of the deposition begins or as soon thereafter as the disqualification becomes known or could be discovered, with reasonable diligence. As to competency or relevancy of evidence. Objections to the competency of a witness or the competency, relevancy, or materiality of testimony are not waived by failure to make them before or during the taking of the deposition, unless the ground of the objection is one which might have been obviated or removed if presented at that time. As to oral examination and other particulars, errors and irregularities occurring at the oral examination in the manner of taking the deposition, in the form of the questions or answers, in the oath or affirmation, or in the conduct of the parties and errors of any kind which might be obviated, removed, or cured if promptly prosecuted, are waived unless reasonable objection thereto is made at the taking of the deposition. As to form of written interrogatories. Objections to the form of written interrogatories submitted under sections 25 and 26 of this rule are waived unless served in writing upon the party propounding them within the time allowed for serving succeeding cross or other interrogatories, and within 3 calendar days after service of the last interrogatories authorized. As to manner of preparation. Errors and irregularities in the manner in which the testimony is transcribed or the deposition is prepared, signed, certified, sealed, endorsed, transmitted, filed, or otherwise dealt with by the officer under sections 17, 19, 20, and 26 of this rules are waived unless a motion to suppress the deposition or some part thereof is made with reasonable promptness after such defect is, or with due diligence might have been ascertained. Rule 24 Depositions before action or pending appeal. Section 1. Depositions before action, petition. A person who desires to perpetuate his or her own testimony or that of another person regarding any matter that may be cognizable in any court of the Philippines may file a verified petition in the court of the place of the residence of any expected adverse party. Section 2. Contents of petition. The petition shall be entitled in the name of the petitioner and shall show, a. that the petitioner expects to be a party to an action in a court of the Philippines but is presently unable to bring it or cause it to be brought. B. The subject matter of the expected action and his or her interest therein. C. The facts which he or she desires to establish by the proposed testimony and his or her reasons for desiring to perpetuate it. D. The names or a description of the persons he or she expects will be adverse parties and their addresses so far as known. And E. The names and addresses of the persons to be examined and the substance of the testimony which he or she expects to elicit from each, and shall ask for an order authorizing the petitioner to take the depositions of the persons to be examined named in the petition for the purpose of perpetuating their testimony. Section 3. Notice and service. The petitioner shall serve a notice upon each person named in the petition as an expected adverse party, together with a copy of the petition, stating that the petitioner will apply to the court, at a time and place named therein, for the order described in the petition. At least 20 calendar days before the date of the hearing, the court shall cause notice thereof to be served on the parties and prospective deponents in the manner provided for service of summons. Section 4. Order and examination. If the court is satisfied that the perpetuation of the testimony may prevent a failure or delay of justice, it shall make an order designating or describing the persons whose deposition may be taken and specifying the subject matter of the examination and whether the depositions shall be taken upon oral examination or written interrogatories. The depositions may then be taken in accordance with Rule 23 before the hearing. Section 5. Reference to court. For the purpose of applying Rule 23 to depositions for perpetuating testimony, each reference therein to the court in which the action is pending shall be deemed to refer to the court in which the petition for such deposition was filed. Section 6. Use of deposition. If a deposition to perpetuate testimony is taken under this rule, or if, although not so taken, it would be admissible in evidence, it may be used in any action involving the same subject matter subsequently brought in accordance with the provisions of Sections 4 and 5 of Rule 23. Section 7. Depositions pending appeal. If an appeal has been taken from a judgment of a court, including the Court of Appeals in proper cases, or before the taking of an appeal if the time therefore has not expired, the court in which the judgment was rendered may allow the taking of depositions of witnesses to perpetuate their testimony for use in the event of further proceedings in the said court. In such case, the party who desires to perpetuate the testimony may make a motion in the said court for leave to take the depositions, upon the same notice and service thereof as if the action was pending therein. The motion shall state, a. the names and addresses of the persons to be examined and the substance of the testimony which he or she expects to elicit from each, and b. the reason for perpetuating their testimony. If the court finds that the perpetuation of the testimony is proper to avoid a failure or delay of justice, it may make an order allowing the depositions to be taken, and thereupon the depositions may be taken and used in the same manner and under the same conditions as are prescribed in these rules for depositions taken in pending actions. Rule 25. Interrogatories to parties. Section 1. Interrogatories to parties, service thereof. Upon ex parte motion, Any party desiring to elicit material and relevant facts from any adverse party shall file and serve upon the latter written interrogatories to be answered by the party served, or, if the party served is a public or private corporation or a partnership or association, by any officer thereof competent to testify in its behalf. Section 2. Answer to interrogatories. The interrogatories shall be answered fully in writing and shall be signed and sworn to by the person making them. The party upon whom the interrogatories have been served shall file and serve a copy of the answers on the party submitting the interrogatories within 15 calendar days after service thereof, unless the court, on motion and for good cause shown, extends or shortens the time. Section 3. Objections to interrogatories. Objections to any interrogatories may be presented to the court within 10 calendar days after service thereof, with notice as in case of a motion, and answers shall be deferred until the objections are resolved, which shall be at as early a time as is practicable. Section 4. Number of interrogatories. No party may, without leave of court, serve more than one set of interrogatories to be answered by the same party. Section 5. Scope and use of interrogatories. Interrogatories may relate to any matters that can be inquired into under Section 2 of Rule 23, and the answers may be used for the same purposes provided in Section 4 of the same rule. Section 6. Effective failure to serve written interrogatories. Unless thereafter allowed by the court for good cause shown and to prevent a failure of justice, a party not served with written interrogatories may not be compelled by the adverse party to give testimony in open court, or to give a deposition pending appeal. Rule 26. Admission by adverse party. Section 1. Request for admission. At any time after issues have been joined, a party may file and serve upon any other party a written request for the admission by the latter of the genuineness of any material and relevant document described in and exhibited with the request, or of the truth of any material and relevant matter of fact set forth in the request. Copies of the documents shall be delivered with the request unless copies have already been furnished. Section 2. Implied admission. Each of the matters of which an admission is requested shall be deemed admitted unless, within a period designated in the request, which shall not be less than 15 calendar days after service thereof, or within such further time as the court may allow on motion, the party to whom the request is directed files and serves upon the party requesting the admission a sworn statement either denying specifically the matters of which an admission is requested or setting forth in detail the reasons why he or she cannot truthfully either admit or deny those matters. Objections to any request for admission shall be submitted to the court by the party requested within the period for and prior to the filing of his or her sworn statement as contemplated in the preceding paragraph, and his or her compliance therewith shall be deferred until such objections are resolved, which resolution shall be made as early as practicable. Section 3. Effective admission. Any admission made by a party pursuant to such request is for the purpose of the pending action only and shall not constitute an admission by him or her for any other purpose, nor may the same be used against him or her in any other proceeding. Section 4. Withdrawal. The court may allow the party making an admission under this rule, whether express or implied, to withdraw or amend it upon such terms as may be just. Section 5. Effective failure to file and serve request for admission. Unless otherwise allowed by the court for good cause shown and to prevent a failure of justice, a party who fails to file and serve a request for admission on the adverse party of material and relevant facts at issue which are, or ought to be, within the personal knowledge of the latter, shall not be permitted to present evidence on such facts. Rule 27. Production or inspection of documents or things. Section 1. Motion for production or inspection, order. Upon motion of any party showing good cause therefore, the court in which an action is pending may, a. order any party to produce and permit the inspection and copying or photographing, by or on behalf of the moving party, of any designated documents, papers, books, accounts, letters, photographs, objects or tangible things, not privileged, which constitute or contain evidence material to any matter involved in the action and which are in his or her possession, custody or control, or b. order any party to permit entry upon designated land or other property in his or her possession or control for the purpose of inspecting, measuring, surveying, or photographing the property or any designated relevant object or operation thereon. The order shall specify the time, place, and manner of making the inspection and taking copies and photographs, and may prescribe such terms and conditions as are just. Rule 28. Physical and mental examination of persons. Section 1. When examination may be ordered. In an action in which the mental or physical condition of a party is in controversy, the court in which the action is pending may in its discretion order him or her to submit to a physical or mental examination by a physician. Section 2. Order for examination. The order for examination may be made only on motion for good cause shown and upon notice to the party to be examined and to all other parties, and shall specify the time, place, manner, conditions and scope of the examination and the person or persons by whom it is to be made. Section 3. Report of findings. If requested by the party examined, the party causing the examination to be made shall deliver to him or her a copy of a detailed written report of the examining physician setting out his or her findings and conclusions. After such request and delivery, the party causing the examination to be made shall be entitled upon request to receive from the party examined a like report of any examination, previously or thereafter made, of the same mental or physical condition. If the party examined refuses to deliver such report, the court on motion and notice may make an order requiring delivery on such terms as are just, and if a physician fails or refuses to make such a report, the court may exclude his or her testimony if offered at the trial. Section 4. Waiver of privilege. By requesting and obtaining a report of the examination so ordered or by taking the deposition of the examiner, the party examined waives any privilege he or she may have in that action or any other involving the same controversy, regarding the testimony of every other person who has examined or may thereafter examine him or her in respect of the same mental or physical examination. Rule 29. Refusal to comply with modes of discovery. Section 1. Refusal to answer. If a party or other deponent refuses to answer any question upon oral examination, the examination may be completed on other matters or adjourned as the proponent of the question may prefer. The proponent may thereafter apply to the proper court of the place where the deposition is being taken for an order to compel an answer. The same procedure may be availed of when a party or a witness refuses to answer any interrogatory submitted under Rules 23 or 25. If the application is granted, the court shall require the refusing party or deponent to answer the question or interrogatory, and if it also finds that the refusal to answer was without substantial justification, it may require the refusing party or deponent or the counsel advising the refusal, or both of them, to pay the proponent the amount of the reasonable expenses incurred in obtaining the order, including attorney's fees. If the application is denied and the court finds that it was filed without substantial justification, the court may require the proponent or the counsel advising the filing of the application, or both of them, to pay to the refusing party or deponent the amount of the reasonable expenses incurred in opposing the application, including attorney's fees. Section 2. Contempt of court. If a party or other witness refuses to be sworn or refuses to answer any question after being directed to do so by the court of the place in which the deposition is being taken, the refusal may be considered a contempt of that court. Section 3. Other consequences. If any party or an officer or managing agent of a party refuses to obey an order made under Section 1 of this rule requiring him or her to answer designated questions, or an order under Rule 27 to produce any document or other thing for inspection, copying, or photographing, or to permit it to be done, or to permit entry upon land or other property, or an order made under Rule 28 requiring him or her to submit to a physical or mental examination, the court may make such orders in regard to the refusal as are just, and, among others, the following. An order that the matters regarding which the questions were asked, or the character or description of the thing or land, or the contents of the paper, or the physical or mental condition of the party, or any other designated facts shall be taken to be established for the purposes of the action in accordance with the claim of the party obtaining the order. An order refusing to allow the disobedient party to support or oppose designated claims or defenses, or prohibiting him or her from introducing in evidence designated documents or things or items of testimony, or from introducing evidence of physical or mental condition. An order striking out pleadings or parts thereof, or staying further proceedings until the order is obeyed, or dismissing the action or proceeding or any part thereof, or rendering a judgment by default against the disobedient party, and, in lieu of any of the foregoing orders or in addition thereto, an order directing the arrest of any party or agent of a party for disobeying any of such orders except an order to submit to a physical or mental examination. Section 4. Expenses on refusal to admit. If a party, after being served with a request under Rule 26 to admit the genuineness of any document or the truth of any matter of fact, serves a sworn denial thereof, and if the party requesting the admissions thereafter proves the genuineness of such document or the truth of any such matter of fact,
1 o'clock.
he or she may apply to the court for an
1
order
o'clock.
requiring the other party to pay him or her the reasonable expenses incurred in making such proof, including reasonable attorney's fees. Unless the court finds that there were good reasons for the denial or that admissions sought were of no substantial importance, such order shall be issued. Section 5. Failure of party to attend or serve answers. If a party or an officer or managing agent of a party willfully fails to appear before the officer who is to take his or her deposition after being served with a proper notice, or fails to serve answers to interrogatories submitted under Rule 25 after proper service of such interrogatories, the court on motion and notice may strike out all or any part of any pleading of that party, or dismiss the action or proceeding or any part thereof, or enter a judgment by default against that party, and in its discretion, order him or her to pay reasonable expenses incurred by the other, including attorney's fees. Section 6. Expenses against the Republic of the Philippines. Expenses and attorney's fees are not to be imposed upon the Republic of the Philippines under this rule. Rule 30 Trial. Section 1. Schedule of trial. The parties shall strictly observe the scheduled hearings as agreed upon and set forth in the pretrial order. The schedule of the trial dates, for both plaintiff and defendant, shall be continuous and within the following periods. The initial presentation of plaintiff's evidence shall be set not later than 30 calendar days after the termination of the pretrial conference. Plaintiff shall be allowed to present its evidence within a period of 3 months or 90 calendar days, which shall include the date of the judicial dispute resolution, if necessary. The initial presentation of defendant's evidence shall be set not later than 30 calendar days after the court's ruling on plaintiff's formal offer of evidence. The defendant shall be allowed to present its evidence within a period of 3 months or 90 calendar days. The period for the presentation of evidence on the third, fourth, etc. Party claim, counterclaim, or cross-claim shall be determined by the court, the total of which shall in no case exceed 90 calendar days, and if deemed necessary, the court shall set the presentation of the parties' respective rebuttal evidence, which shall be completed within a period of 30 calendar days. The trial dates may be shortened depending on the number of witnesses to be presented, provided that the presentation of evidence of all parties shall be terminated within a period of 10 months or 300 calendar days. If there are no third, fourth, etc. party claim, counterclaim, or cross-claim, the presentation of evidence shall be terminated within a period of 6 months or 180 calendar days. The court shall decide and serve copies of its decision to the parties within a period not exceeding 90 calendar days from the submission of the case for resolution, with or without memoranda. N. Section 2. Adjournments and postponements. A court may adjourn a trial from day to day, and to any stated time, as the expeditious and convenient transaction of business may require, but shall have no power to adjourn a trial for a longer period than one month for each adjournment, nor more than 3 months in all, except when authorized in writing by the court administrator, Supreme Court. The party who caused the postponement is warned that the presentation of its evidence must still be terminated on the remaining dates previously agreed upon. Section 3. Requisites of motion to postpone trial for absence of evidence. Deleted. Section 3. Requisites of motion to postpone trial for illness of party or counsel. A motion to postpone a trial on the ground of illness of a party or counsel may be granted if it appears upon affidavit or sworn certification that the presence of such party or counsel at the trial is indispensable and that the character of his or her illness is such as to render his or her non-attendance excusable. Section 4. Hearing days and calendar call. Trial shall be held from Monday to Thursday, and courts shall call the cases at exactly 8:30 a.m. and 2 p.m., pursuant to Administrative Circular Number 3-99. Hearing on motions shall be held on Fridays, pursuant to Section 8, Rule 15. All courts shall ensure the posting of their court calendars outside their courtrooms at least one day before the scheduled hearings, pursuant to OCA Circular Number 250-2015. Section 5. Order of trial. Subject to the provisions of Section 2 of Rule 31, and unless the court for special reasons otherwise directs, the trial shall be limited to the issues stated in the pretrial order and shall proceed as follows. The plaintiff shall adduce evidence in support of his or her complaint. The defendant shall then adduce evidence in support of his or her defense, counterclaim, cross-claim, and third-party complaint, determined by the court, the total of which shall in no case exceed 90 calendar days, and the third-party defendant, if any, shall adduce evidence of his or her defense, counterclaim, cross-claim, and fourth-party complaint. The fourth party, and so forth, if any, shall adduce evidence of the material facts pleaded by them. The parties against whom any counterclaim or cross-claim has been pleaded shall adduce evidence in support of their defense, in the order to be prescribed by the court. The parties may then respectively adduce rebutting evidence only, unless the court, for good reasons and in the furtherance of justice, permits them to adduce evidence upon their original case, and upon admission of the evidence, the case shall be deemed submitted for decision, unless the court directs the parties to argue or to submit their respective memoranda or any further pleadings. If several defendants or third-party defendants, and so forth, having separate defenses appear by different counsel, the court shall determine the relative order of presentation of their evidence. Section 6. Oral offer of exhibits. The offer of evidence, the comment or objection thereto, and the court ruling shall be made orally in accordance with Sections 34 to 40 of Rule 132. N. Section 7. Agreed statement of facts. The parties to any action may agree, in writing, upon the facts involved in the litigation and submit the case for judgment on the facts agreed upon, without the introduction of evidence. If the parties agree only on some of the facts in issue, the trial shall be held as to the disputed facts in such order as the court shall prescribe. 6. Section 7. Statement of judge. Deleted. Section 8. Suspension of actions. The suspension of actions shall be governed by the provisions of the Civil Code and other laws. Section 9. Judge to receive evidence. Delegation to clerk of court. The judge of the court where the case is pending shall personally receive the evidence to be adduced by the parties. However, in default or ex parte hearings, and in any case where the parties agree in writing, the court may delegate the reception of evidence to its clerk of court who is a member of the bar. The clerk of court shall have no power to rule on objections to any question or to the admission of exhibits, which objections shall be resolved by the court upon submission of his or her report and the transcripts within 10 calendar days from termination of the hearing. End of Rule 30.